The first type of discovery that I like to talk about is the request for admissions. The idea behind the request for admissions is really simple. If the sides in a lawsuit agree upon a particular fact, no one should have to prove it. This should save everyone time, effort, and money. So, a procedure was created where one side can ask the other side to admit that a set of facts are true or that documents are genuine, and if they're admitted, then they don't need to be proven at trial, and the court will simply assume them to be true. In the context of self-represented litigants, however, I've tended to see this used to sucker punch them. The reason for this is because the penalty for failing to respond to a request for admissions is particularly brutal. Specifically, if one side sends out a request for admissions and the other side does not respond to them, then the side that sent them out can file a motion with the court asking the court to deem that each of the facts are true or documents are genuine. So what will often happen in a case involving a self-represented party is one side will send out all of the facts that are necessary to prove the case or a defense and ask that they be admitted. When there's no response, a motion to deem these admissions as admitted is filed.
Once this motion is filed, if the responding party does not serve responses to the request for admissions prior to the date of the motion, then the court will deem each of the facts to be true or documents are genuine. As a result, if the requesting party had requested each of the facts necessary to win the case be deemed true, the responding party has effectively lost the case. If responses are served prior to the motion, they will not be deemed true. However, this type of motion carries with it mandatory attorney's fee sanctions, so the side filing the motion will request its attorney's fees for the cost of filing the motion, and these attorney's fees are due whether or not a response is served prior to the date of the motion. As a result, a number of law offices are very anxious to file this type of motion upon the responding party missing their deadline to respond. The procedure for propounding a request for admissions is the same as every other type of discovery we are discussing during this presentation. First, the asking side completes the request for admissions form and attachment, or creates their own request for admissions on 28-line pleading paper. A copy of this request for admissions is then served on the responding party. If the responding party is either the plaintiff or a defendant who has already filed a first appearance in the case, such as an answer, service by mail is acceptable, and a copy of the proof of service is mailed along with the request. The original request for admissions and proof of service are retained by the asking party. They are not filed with the court at this time. Although it is possible to create your own request for admissions using 28-line pleading paper, during this presentation we will be using the Judicial Counsel Form DISC-020, which simplifies the process somewhat. This form is somewhat self-explanatory and follows the formatting conventions of any other Judicial Counsel form. In the top box, where it says attorney or party without attorney, since you are representing yourself, this will be your name, address, telephone number, and where it says attorney for, in pro per. In the box that says Superior Court of California, County of, write the name of the county in which your case is being heard, as well as the court address and the branch name of the court. Short title is the last name of the plaintiff, the letter V for versus, and the last name of the defendant. If either of these parties is a corporate entity, LLC, or other business entity, you may use an abbreviated version of that party's name. In the box that says case number, write the case number of your case. And finally, in the box that says request for admissions, you will have two check boxes, one that says truth of facts, the other that says genuineness of documents. If you are going to ask the responding side to answer whether or not a fact is true, check truth of facts. If you are asking them to admit that documents are genuine, check genuineness of documents. Be sure to check at least one of these two boxes, and it is possible to use both of them. The name of the requesting party is your name. The responding party is the name of the party that you wish to respond. This is not the name of the attorney on the other side or any individual witness inside a corporation or LLC unless that person is listed as a plaintiff or a defendant in the case. If the responding party is a corporation, they will choose the person most knowledgeable who will respond and verify their responses. Set number will start at 1. If this is the first set of requests for admissions that you are sending to a particular party, use set 1. If this is the second set to that same party, set 2, and so on. Now I'd like to show you something that will make you smarter than some of the attorneys out there. If you go ahead and look toward the middle of the page, you will see a date and signature line. For some reason, some attorneys can't resist the urge to date and sign whenever given the opportunity. However, if you read this very carefully, you will realize that the date and signature line is actually part of the instructions to the responding party and asking party in the case. This portion of the instruction simply tells the responding party that they should have the following language above their signature line. I declare under penalty of perjury under the laws of the state of California that the foregoing answers are true and correct. Your signature line will be at the bottom. At the bottom of the page, you will notice that there are 2 numbered paragraphs, 1 and 2. Each one has a checkbox. If you checked truth of facts at the top of the page, checkbox 1, each of the following facts are true. There's this tiny spot that you can use to write the facts that you wish the other side to use. However, the space is really not good for more than perhaps 1 fact, so you'll probably check the continued on attachment 1 box instead. If you checked truth of documents up at the top of the page, check box number 2, and once again, check the continued on attachment 2 box if you plan on attaching another page rather than use the tiny space provided. Then, at the bottom of the page, print your name on the left-hand side. Your signature will be on the right-hand side. If you checked the continued on attachment 1 box, attach an additional page and label it attachment 1 at the top. This is typically done on 28-line pleading paper. However, you may use any blank sheet of paper or the attachment to Judicial Council form. Below the word attachment 1, have a numbered list with each numbered item asking the other side to admit a single fact. Each numbered item may contain only 1 fact, so if you find yourself using the word and, or, semicolons, periods, or many commas, you are probably asking the other side to admit 2 or more different facts, and the request would be objectionable as impermissibly compound. Each fact that you ask should establish one of the elements that you need to establish for one of your causes of action if you are the plaintiff, or one of the elements you need to establish for one of your affirmative defenses if you're the defendant. You may also use the request to try to establish a fact that would disprove one of the facts necessary for the plaintiff to establish a cause of action if you're the defendant, or disprove one of the elements that would establish an affirmative defense if you're the plaintiff. I typically like to write the request in the form, admit that, just to remind myself of what type of question that I'm asking. As you write these requests, be sure to always write the request so that if the fact is deemed true, it helps your case. One time, I had a person come through who had a beautifully written set of requests for admissions. He had served this on the attorney for the other side and received no response. I read the requests, and it had things such as, admit that the plaintiff entered into an agreement with the defendant on, and then a specific date. Admit that the defendant breached the agreement on a specific date. Admit that the plaintiff has been harmed by the breach, etc. And as I read through all of these, they all seemed very good as it would establish the causes of action in the complaint. And then I realized that I was talking to the defendant. Because the remedy, if the responding side doesn't respond, is to ask the court for an order deeming that each of the admissions is true, had he filed a motion to deem them all true, he would have lost his case. So it's obvious why the other side didn't answer. So be sure to write your requests so that if they are true, they help your case. Many self-represented litigants also make the mistake of putting too much into their requests for admissions. Although these are useful for taking facts off of the table, assuming that the other side responds, they are generally not particularly useful for obtaining new information about the case or obtaining any type of evidence. All that can be asked with a request for admissions is that the other side admit that something is true or deny that it is true. You do not get to ask any who, what, when, why, how, or when questions. Those are interrogatories, which we'll talk about in just a bit. One of the most common questions I receive is, how can I know what I should ask the other side to admit? Perhaps the best source for knowing the facts that need to be established in your case is to read the jury instructions for each cause of action, or the jury instructions for each affirmative defense that has been raised in the case. If you've ever served on a jury, you know that after the case is completed and you are sent to deliberate, the judge will give you a set of instructions detailing what you must find to establish each of the causes of action by the plaintiff or each of the affirmative defenses by the defendant. These instructions were generally not made up, but come from a standardized set of instructions used by the court. These can be downloaded at www.courts.ca.gov/partners/juryinstructions.html. Although this book is long, it is well indexed, and there is one or more jury instruction for each cause of action that can be brought and each affirmative defense that can be raised. If you read these instructions, they will describe in roughly plain English what you must establish, and if you know it must be established, you know the facts that you must prove to establish that, and therefore what you must ask the other side to admit.